Hello, welcome back to Legal Brain. Today, I'm going to discuss yet another important area, and that is minus contract. So, in exam point of view, I'm going to discuss what do you mean by a minus contract, what is the effect of a minus contract, and the landmark case law. So, listen to the class and try to understand. First of all, I would like to discuss about the meaning and definition of Section 11. Section 11 speaks about capacity to contract, and by virtue of Section 11, it says that if a person is competent to contract, if he has attained the age of majority, that is the first point, he should have attained the age of majority, that is 18 years. The second point is that he should be of a sound mind person, Sound mind means the person who should be mentally fit to enter into a contract. Third one is that he should not be disqualified by any law of the land from contracting. The meaning is that law should not have imposed a restriction on a person to enter into a contract. And if law is restricted, law is restricting a particular person from entering into a contract, then he is disqualified by law. So these are the major 3 points. First one is he should have attained the age of majority, that is 18 years of age. Second one is that he should be a person of sound mind, that he should be mentally fit. Third one is that he should not be disqualified by any law from contracting. So these are the major points. So I'm going to discuss next is, I'm going to discuss about persons disqualified from entering into a contract. That means who are the person who are restricted or disqualified or prohibited from entering into a contract. The first category of persons are minors. That means the person who are below 18 years of age. Second category is that persons of unsound mind, just opposite as of that of a sound mind. That means mentally unfit persons are unsound minded persons. They are restricted or disqualified from entering into a contract. Third category is persons disqualified to contract by any law of the land. Mainly insolvents are restricted from entering into a contract. These are the persons who are disqualified from entering into a contract. Now, I'm going to discuss in detail in this class about minors and minors agreements. So look into the screen and try to understand who is a minor. Section 3 of Indian Majorities Act of 1875 gives the definition of a minor and says that a minor is a person who has not attained the age of 18 years. So all the underage people, below 18 years, they are treated as minors and they are not supposed to enter into a contract. And now I'm going to discuss about the rules relating to an agreement with a minor one by one. The first and foremost rule is that the law always protects the minors from their own inexperiences and against the possible improper designs of those of more experienced one. The second law is that the law should not cause any hardships to the persons or the people who deal and dealt with the minors. So these are the major 2 rules. First one is that the law always protect the minor from the hardships or the inexperiences they have. Second one is that the law also protect the unnecessary hardships to the person who deal with the minors. Now I'm going to discuss the very important landmark case law falling under minors contract. In exam point of view, this is very important case law. That is MOHORI BIBEE versus DHARMODAS GHOSE. And this is a landmark case law falling under minors contract and which is very important. And now I'm going to discuss the facts, the issues, and the judgment in exam point of view. First of all, I would like to discuss about the facts of the case, which is very essential. The facts of this particular case is that there was a minor boy and his, DHARMODAS GHOSE, while he was a minor, that is the minor's name, DHARMODAS GHOSE, while he was a minor, he entered into an agreement with Brahmodat, that is the, opponent, who was a money lender. And to secure a loan of 20,000 rupees, at the time of the transaction, the attorney, that means the advocate of the Brahmodat, who was was an attorney and who acted on behalf of the money lender, he was having the knowledge that this particular DHARMODAS GHOSE was a minor boy, and he already informed this to Brahmadat, but he doesn't care about that. And later, the minor brought an action against the defendant, stating that he is a minor person and he was minor when the mortgage was executed by him, and therefore the particular mortgage will be void in nature, because we already know that if a minor person enter into a contract, then the particular contract, the effect of the contract will be void ab initio. The meaning is void from the very beginning. So just because this particular minor, Dharmodas Ghosh, he plead for this particular, he plead that the particular contract should be void ab initio in nature, and therefore the mortgage was void and inappropriate, and it's inoperative, and the same should be cancelled. He plead for that. But in this case, the appeal was filed by Brahmodat executors, and they contended that the minor represented his age fraudulently. That means, he was a minor, and he said that he is a major person when he entered into a contract by doing mortgage, and the minor represented his age fraudulently, and therefore law of estoppel should apply. In law of estoppel mainly means that you cannot change something that you already said once. You cannot change that particular statement. So the appeal was based on that particular point, that law of estoppel should apply. And also, if the instrument is cancelled as pleaded by the particular person, Dharmodas, then he should made to pay the loan according to section 64 and 65 of the contract. So this was the facts of the case. That means a minor boy who executed a mortgage from Brahmodat, and the Brahmodat's attorney advocate was having the knowledge that he was a minor boy, and he also communicated it to Brahmodat, but he doesn't care that. And after some time, Dharmodas Ghosh, the minor, he plead for his minority, and he wanted to set aside this particular agreement. And an appeal was filed by the opponent, Brahmodat, and stated that law of estoppel should apply. That means he should not change his words, his statement now. And that means he have said that he is of a person who is of a major age of majority, have attained age of majority, and it should be continued. And the issues involved in this particular case are, the first one is whether the deed was void under section 2, 10 and 11 of Indian Contract Act 1872. The second point was whether the defendant was liable to return the amount of loan which he had received by him under such deed or a mortgage or not. Third point is that whether the mortgage commenced by the defendant was voidable or not. So these are the major issues that fell under this particular case law. And the judgment was given by Privy Council and stated that after considering all the facts of the case, the Privy Council held that the agreement entered into a minor is void ab initio. The meaning is that void from the very beginning. And the court further held regarding the conditions of the contentions of the defendants and held that firstly, the law of estoppel will not apply in this particular case, since the attorney of Brahmodat was already having a knowledge that this boy is a minor boy. He was having knowledge. Secondly, Section 64 and 65 of Indian Contract Act will not apply in this particular case, as there wasn't an agreement at the first place, and for the application of 64 and 65 sections, the contract must be between competent parties. So because of all this reason, a precedent of minors agreement was void ab initio. That means void from the very beginning. I hope this case is clear for you. If you didn't understand, or if you have any queries, please do comment below. I'll repeat it. And these other, facts, issues, and judgment of the case. And next, I'm gonna, discuss about the rules. So the first rule was regarding the landmark case law, and the second rule is regarding no rectification. A minor is not supposed to rectify the agreement. That means a minor cannot rectify the agreement on attaining the age of majority. He cannot say that, okay, now I'm major, I want to rectify the agreement. It is not possible. And the third point is that minor can plead minority to avoid contract. So this is an advantage for the minor. Once when he entered into a contract at the age of, underage, like, when he was a minor, and he can always plead majority, and he can avoid the contract, avoid the liabilities, like, ex a minor. borrows money by saying that he is a major. He entered into a contract like that. Later, he can plead, minority, and he can plead to cancel the agreement, because a minor's agreement is always, void ab initio. That means void from the very beginning. The next point is that a minor is not liable to restore the property or goods. He is not at all liable to restore the property or the goods that he, borrowed. But a minor can be compelled in certain situations if the goods are traceable in his possession. If it is traceable, if he could, find out that it is actually, it's okay to restore that. If the minor has already sold the goods, then nothing can be claimed. Suppose a minor borrowed certain, goods, and it is not traceable, he already sold that, then we cannot, found out that we cannot claim for that. The next point is no specific performance. You know that specific performance is a remedy, by, initiating, we can plead to specifically perform the particular, contract as based on, the particular agreement. But no specific performance is applicable in case of a minor, and means that actual performance of a contract as agreed by the parties under the contract is void ab initio. And there is an exception, like if in case the guardians entered into a contract, if they have the authority and it is for the benefit of the minor, which is valid in nature. Yes, a minor is not at all liable, and no specific performance is applicable in case of a minor. Next point is that a minor can be a promissory or a beneficiary, and which means that a minor is not obliged, or a minor doesn't have a duty to do anything, but he can always get benefits. He can always be a beneficiary. For example, where the minor, bears no obligation or a duty, as I've told you, and rather the agreement is for his own benefit, such agreement is valid. If he's like, trying to get some advantage or a benefit from an agreement, he can actually take that. The next one is that a minor as a partner. A minor cannot be a partner, but he can always get the benefit out of it. Look into the screen. A minor cannot become a partner in a partnership firm, but he can be admitted to benefits of the partnership firm with the consent of all the partners. He can enjoy all the benefit of a, partnership firm, but he cannot be a partner. So the minor is liable to losses, but not on his, personal property. That means he is not at all personally liable. The next point is that minor as an agent, and it says that the principal shall be bound for the acts of the minor agent. The principal and agent relationship, the principal will be liable for the acts of the agent, and here the minor, if the minor is an agent, then the principal will be liable for all the acts which is done by the minor agent. Next point is that the minor cannot be adjudged as insolvent by the court of law. Even for necessaries of his properties, he is not personally liable for anything. And 10th point is that position of a surety, and it says that, a major stands as a surety on behalf of the minor, then the major would be liable, not the minor. The minor will not be having any responsibility. The major person will be acting as a surety, and he will be liable for that. And next point is that the minor's liability for necessary supply. Under quasi-contract, under section 68, we have learned about necessary supply, and it says that under this purview, it says that the minor is liable to pay a reasonable price for the necessary supply to him, but his property is liable, but he is not at all personally liable under this particular concept of quasi-contract. And the next position is that the position of minor's parents, and it says that the parents are not liable for the contract entered by the minor, himself. So the parents will not be liable for any contract entered by the minor, and the minor can always escape by, pleading minority, because the contract or the agreement will always be void in nature. That means void ab initio. So these are the major elements of minor's contract. So I have discussed about minor's contract, effect of minor's contract, the landmark case law, MOHORI BIBEE versus DHARMODAS GHOSE. So this is very important landmark case law. You should study this particular case law and the major rules concerning minor's contract. I hope this is clear. If you do have any queries, any doubt, do comment below. Thank you for listening to me. Thank you.